Welcome to my channel, All for Health with Jane. Family, we are still on the Senzo Meyiwa murder trial, a trial within a trial. Still trying to determine whether the statements that were given by accused number 1 and accused number 2 should be admissible and be used against them in the court of law. Advocate Baloyi introduces AVL or car tracking system report as new evidence to this court. And Advocate Mgomezulu objects to that. He is against that. And in his submission of why is he objecting to this, he gives some reasons. And one of the reasons is that this AVL report was supposed to have introduced in the beginning of a trial within a trial. So this video, or the purpose of this video, is for us to listen to the judge, Rata Mokwatleng, as he responds to Advocate Mgomezulu. He gives his responses answering Advocate Mgomezulu as he has different concerns. So the first concern is that of why was it not introduced at the beginning of a trial within a trial. So let's listen to Judge Rata Mokwatleng.
Consequently, I now address the question whether this evidence relating to a report of the AVL system should have been furnished to the counsels, consequently the accused, at the inception of the trial. But Mr. Baloyi says this evidence only surfaced when Mr. Sergeant Makhano was being cross-examined, because it was only then that the version of accused number 2 was being put to Sergeant Makhano, namely that he was taken to various avenues and locations and assaulted, meaning that this Peugeot, this Fortuna SUV, traversed various locations, and consequently the state apparently is in a position to countervail that evidence, because at this stage there are two versions before this court. Sergeant Makhano is not himself only. Jonathan, all the police denied that accused number 2 was assaulted by them, and number 2 is adamant that he was assaulted. They actually told him, is he still alive? That's how murderous they had assaulted him, this police. And you know, this case has got to do with reputational damage. 2 senior police officers, Mbodlo, who allegedly took one of the confessions, and Rapadu, who allegedly took the other confessions, they are alleged by accused number 2 to have been instrumental in orchestrating what Mr. Mgomezulu calls a severe assault and a severe torture of accused number 4 in order to extract a confession from him. These are senior police officers. This court has a duty, if constitutional rights of an accused person are being transgressed, to refer that exigency to the relevant authorities. Consequently, that is why this court must have access to all the evidence in order to traverse all the evidence objectively.
Family, one of the reasons why maybe Advocate Mgomezulu is objecting to the AVL tracker, maybe it's because already they have been given this report as the defense, and he already knows what is inside the report. He knows what is transpiring there. Hence, he's not comfortable to continue with this. He's not comfortable for the state to present this to the court. And what Judge Rata is saying in the next clip is that he, as the judge, does not know what is in the report yet, which is normal anyway, because the state and the defense would be the first to see any evidence and they will present it to the court before the court can be given a copy of that evidence. So let's listen to Judge Rata.
To enable the court to see that justice is done, the prosecutor is expected at all times to act in a manner which is responsible and fair to the accused and to be open and candid to the court. Consequently, he's going to present and place all the material before this court, as Mr. Baloyi is attempting to do. He says there's evidence which, according to him, if this court can hear, it may find that it is relevant. I don't know if that evidence is relevant or not. And the prosecutor's duty, unlike that of a defense counsel, his primary duty is to assist the court in ascertaining the truth.
Judge Rata further says there is no rule that is against the state introducing new evidence as long as that evidence has to do with the assisting of the case to be solved. So let's listen to Judge Rata.
It says, there is no absolute rule that the trial court's discretion to admit evidence for the state after the close of the defense case should be limited to the situation when new matter is introduced which the state could not foresee. That's the law in South Africa. I'll repeat it. There is no absolute rule that the trial court's discretion to admit evidence for the state after the state has closed, after the close of the defense case should be limited to a situation where new matter is introduced which the state could not foresee. An inflexible rule of this sort would hamper the exercise of the judicial officer's discretion. They say I mustn't listen to the evidence. It's an injunction. Each case depends on the facts and the guidelines mentioned in the judicial case, and the new evidence may be allowed without injustice to the accused. Even here, where's the injustice if this court listens to the evidence of the AWVL system? Where's the prejudice to Mr. Tintansi? Where is it? I don't know what the evidence is going to be. But the state submits that if need be, the manufacturers of that system will be called to come and give evidence in explaining the mechanism of that system. And by the way, the accused, through their counsels, are entitled to cross-examine that witness who's going to testify on the efficacy and the utilization of that AVLW machine. So there's no prejudice in hearing that evidence. I take note of what Mr. Ngomezulu says about the evidence of an expert. I'm aware of the cases. And also, I take a judicial notice of what the former president of the SCA, Mpati, said about expert knowledge. He says it's not only acquired from going to university and reading tomes and tomes of books. Sometimes through physical and objective environment of working in a particular workplace for some time, one acquires expert evidence sometimes. You can quote the case of Dr. Barnett, 1968, when he transplanted a heart as the first surgeon in South Africa to do so. He was assisted by a black gentleman, I just forget the name of that gentleman, who actually taught him how to operate. Never went to school, that Xhosa gentleman. And he was acknowledged as an expert in anatomy of the heart. You are aware of that history, Mr. Mgomezo?
No, I'm not aware, man.
You're not? Were you born then? 1968, says Barnett. So Mpati is referring to that. To say, no, you don't have to study necessarily to acquire expert knowledge. You can acquire same by being in the environment.
In terms of the relevancy of this evidence that Advocate Baloyi wants to introduce, Judge Ratha says the following.
Conditions mentioned by courts as guidelines include the following: the reasons why the evidence was not led previously. Because in this case, apparently, Mr. Baloyi says it was only discovered when the version of accused number 2 was put to Sergeant Mokhano. The degree of the relevance of the evidence. This evidence is relevant to this court because it involves, allegedly, through the version of accused number 4, senior officers, colonels, abusing their position and infracting on the constitutional rights of accused number 2 by assaulting him viciously. So that is the relevance of that evidence. Because I will have forensic, scientific evidence of a machine, not a human being. And I'm sure a machine is not biased. I've heard everything, but I've never heard of a biased machine. So, it is relevant. And the reasons why the evidence was not led previously, as explained by Mr. Baloyi, is that it was just found recently, and also the possible prejudice to the other party, such as the fact that a rebutting witness may no longer be available. Mr. Ntasi, accused number 2, is available to rebut that evidence.
Family, Judge Ratha emphasizes that as long as it is in the interest of justice to introduce this new evidence, the state will be permitted to do it. So let's listen at this final clip.
But here, this evidence is relevant. Like I say, it's interlinked to the evidence which was given by Mokhano, and it is also interlinked to the assertion which were put to this witness that that vehicle traversed certain locations, and that vehicle facilitated the assault on accused number 4, because it took him to Tembisa, Orlando, Alberton, Paraguanas, everywhere. So that's the cogency of that evidence, I believe, can assist this court in establishing the truth. And they say if the evidence is relevant, then it operates as a legal rule. Although of necessity, it has to be very flexible, and it's not to be subjected to further vagaries of a judicial discretion. I've quoted all the authorities. I don't have to read them. But the primary principle here is it in the interest of justice to allow that evidence to be heard? Is that evidence which Mr. Ngomezulu says I shouldn't hear, is it relevant in this case? On both accounts, I find that it is, and consequently the state is allowed to lead that evidence.
Judge Rata has made a decision. The matter is closed. This AVL tracking report will be used in this court as evidence. Advocate Mgomezulu has to abide family. So let's wait for the court to give the defense a chance to cross-examine Sergeant Mokhano on this AVL report. Hopefully, there will be some progress on this in terms of solving this case. Thank you very much, family, for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. Thank you. Bye.